My name is John Eastman. I'm the chairman of the Federalism and Separation of Practice Group, Separation of Powers Practice Group, and we got some new marching orders this morning at our practice group leaders meeting, and that is to maybe introduce our moderators because they're people of distinction, but also to take a brief moment to invite all of you who might be interested in further and additional involvement with this particular practice group to contact me or Dean Reuter to let us know of your interest so we can enlist your help in the various things that the practice group does. Now it's my distinct pleasure to introduce the moderator of our panel today on competitive versus cooperative federalism, Judge Carlos Bea. Now, he thinks we always invite him because of his great intellect, but we really invite him here because we get to see Louise more with that. No, just kidding. He joined us direct from San Sebastian, Spain, via Cuba and San Francisco, and I'll leave it to you all to decide which was the more tyrannical of the regimes that he lived under in those days. But I learned something new in trying to prepare these brief remarks to introduce him, that he played for Cuba on the basketball team in the, I won't say what year, but in the Helsinki Olympics. You can look that up. But we've got a particular momentous occasion because just last month he celebrated his 10th anniversary on the Ninth Circuit Court of Appeals. So we're delighted to have Judge Carlos Bea moderate this panel. Judge Bea.
Thank you, John. Thank you very much, John. It's a pleasure to be here again and see all your shining faces for what I consider to be a really precedent-breaking type of panel. This is a type of panel which goes to the very roots of our system of government, and it will be presented by some distinguished persons. The topic of the panel is competitive federalism versus cooperative federalism. And I'll try to bring that into focus with some reading I did of Michael Gravy's book, where he discusses the two concepts. The issue is not so much how much federalism we should have, but what kind of federalism we should have. As Madison said in Federalist 51, the great difficulty in forming a government which is to be administered by men over men is that you must first enable the government to control the governed, and in the next place, to control itself. Cooperative federalism, and this is my reading of what Gravy was talking about, and I issue this disclaimer, he might disagree with me. Cooperative federalism is a bargaining process between states and the federal government over the allocation of power amongst them. This leads to incessant aggrandizement of governmental power over the lives of the citizens because the bargaining is for the benefit of politicians and public and political elites. As Hamilton said, it tends to center on, quote, power, emoluments, and consequences of office. It is essentially the state seeking federal regulation for the purpose of imposing cartel conditions among the otherwise competing states in matters such as employment practices, taxes, and areas of regulation. Competitive federalism, on the other hand, seeks to limit the uniformity among the states to allow states to compete with each other with greater power of the state to decide upon what and how to provide public goods. If individuals and firms are mobile, they can choose from the, quote, varying bundles of public services and taxes. The states are forced to compete to retain productive individuals and firms. Information is generated as to what government programs work. The process tends to discipline government. Gravy sees the federal courts as agents for both kinds of federalism. On the one hand, Supreme Court precedents tend to cartelize and remove competitive differences by decisions requiring state uniformity, such as death penalty procedures and the rights of abortion. On the other hand, its precedents maintain economic competition across state borders through the dormant Commerce Clause. Our speakers today, and I'll introduce them in the order in which they're going to speak. Unfortunately, Harry Newborn of NYU called in. He's engaged in litigation, and he cannot appear today, so we have 4 instead of 5 speakers. First, John Baker, who's probably known to all of you, frequent contributor here. He's a visiting professor at Georgetown Law School and also a visiting fellow at Oriel College, Oxford. He has taught at many law schools, including Catholic University, George Mason, NYU Law School, and several foreign universities. He teaches several subjects: constitutional law with an emphasis on federalism and separation of powers, anti-terrorism law, and healthcare law. He appears as counsel frequently in federal courts, including 2 appearances in the Supreme Court of the United States. He also teaches courses for the Federalist Society on separation of powers with Justin Antonin Scalia. He's authored books on criminal law and the law of the United States. He's a co-founder of Stratfor, a global intelligence agency, and has co-authored its first book, The Intelligence Edge. Next to speak, let's see if I got my lineup correct, will be Professor Robert Mikos, who's a professor of law and director of law and government at Vanderbilt University Law School. Professor Mikos specializes in federalism and criminal law issues, principally these days on marijuana legalization and immigration reform. He has written on political safeguards of federalism and the economics of private precautions against crime. Professor Mikos graduated summa cum laude at the University of Michigan Law School, where he was an articles editor on the Law Review. He clerked for Chief Judge Michael Boudin of the First Circuit. He taught at UC Davis and Notre Dame courses in federalism, constitutional law, and drug policy. Professor Erin Ryan will be the next speaker, and she's over here on my left. She teaches these days at Lewis and Clark Law School in Portland. She's a graduate of Harvard Law School and editor of the Harvard Law Review. She clerked for our late and beloved Chief Judge James Browning of the Ninth Circuit, whose name was added to the building a couple of years ago, so it's now the James R. Browning Federal Courthouse in San Francisco. Before practicing environmental law, land use law, governmental, and law in San Francisco. In 2004, Professor Ryan went into academia, first to William & Mary Law School, then to Northwestern, and now at Lewis and Clark. Professor Ryan teaches federalism, property, land use, natural resources, and water law. She has consulted with numerous organizations and institutions to develop sustainability programs. She has written in newspapers here and abroad and appeared on PBS NewsHour, National Public Radio, and she is the author of many scholarly works, including Federalism and the Tug of War Within. That is Oxford 2012. Last, but certainly not least, Professor Dr. Jörg Fedke, who's a professor of comparative and international law at Tulane Law School and director of some German programs there, where he's been since 2009. A true internationalist, Professor Fedke has studied in Zambia, the Philippines, and Germany at the University of Hamburg. He took his PhD analyzing South Africans' post-apartheid constitutional law. He has also taught at the University College in London and as a professor of comparative law. His main research interests are constitutional law, election law, comparative methodology, and torts. He's provided advice on federalism to Iraqi National Assembly and to Arab countries on constitutionalism. He's currently advising the initiative Kirkuk and Beyond, strengthening multi-level governance and service provision in a challenging environment. Professor Fedke teaches torts, courses on the law of European Union, comparative constitutional law, and election law. And with that, we'll start off with Professor Baker. The speakers will speak about 8 minutes, then we'll have questions back and forth from them, and then we'll turn to questions from the audience.
Thank you, Judge. This panel really was designed around Michael Grieva, and he was the first person invited. Unfortunately, Michael had a conflict. we wanted to have Michael and Professor Fedke because Michael's understanding or elaboration of comparative or collaborative and competitive federalism is based on his German background. So we wanted two Germans going at it here. So, but we'll modify it a little bit. I'm going to do some theoretical overview, and at the end, Professor Fedke will come back with a comparative view. In between, you'll get two people who actually talk about the realities. So I'll start with the theory, and then we'll leave it to our other two professors to go into more detail about things that you're maybe more interested in. Okay, I want to cover in this overview three things. I mean, federalism, what is it? I mean, you may think, well, we all know what it is. Guess what? We don't. Two, I want to talk about the Prince case because it's a great case to talk about this in. And three, I want to argue that we have both competitive and cooperative federalism. Okay. Today in the U.S., if you say you're a federalist, it normally means that you're tilting away from centralized power and in favor of the states. Yet we know at the founding it was just the opposite. On the other hand, today, even so-called Republicans in Washington, they are more centralizing than the centralizers at the founding. And if you go to Europe, the federalists are the centralizers today. Well, how do you explain all this? Having written a dissertation on federalism, I can tell you it is extremely difficult to define it. There are different examples around the world. And in fact, Madison didn't call it federalism. He called it in Federalist 39 a compound republic, part national and part federal. And of course, today, after the 17th Amendment, it is much less federal and more national than it was. And those of us federalists are constantly struggling against it, but institutionally, that change was significant. On this, Michael and I disagree. I give the 17th Amendment much more importance than Michael does. He and I had this discussion not long ago. Okay, the Prince case. You all remember the Brady gun case. And the Supreme Court held that Congress could not order the chief law enforcement officers in the states to do background checks. They could ask them, they could pay them, but they couldn't force them. What's really interesting in that case is the dissent by Justice Breyer. Now, Justice Breyer says, well, you know, there are different federal forms around the world. And if you look at the European Union, I mean, they give the countries directives, and this seems very nice because it doesn't force them to do it in a certain way, but it allows them to choose how to do it. And he thought that was very reasonable. And Scalia says, that's fine, but that's not our system. But it's more than that's fine, it's not our system. The fundamental point made in the early part of the Federalist is that a confederation, or at the time they called it federation even, doesn't work. And it doesn't work because it is fundamentally wrong to have one sovereign directing another sovereign. You know, they tried that in Chechnya. It didn't work too well. And that is the fundamental break. That is what distinguishes, as Hamilton says over and over again, is the difference between a government and a league of states. Now, that government, as Hamilton says, to be a government, it has to act directly on the people. Whereas in the European Union, you have the center acting on the states, not directly on the people. Now, there are all kinds of accountability issues in here that we could discuss as well. But this significance, we used to call, and in Prince, Justice Scalia does call, dual federalism, meaning that we have two different governments that have certain powers, and each acts directly on the people. Now, what's happened in this country is a distortion of all this. But I want to go on the third point to mention, what do I mean when I say we have both competitive and collaborative or cooperative federalism? We know that the reason for the Constitutional Convention was because the states were competing with each other in a way that was not for the long-term good of any of them. Because of their protectionism, They were inhibiting commerce. So the Constitution came along as a way of creating a certain cooperative zone because Congress had certain powers, namely over commerce among the states. That's the cooperative element. But there are other cooperative elements taken from the Articles, Privileges and Immunities Clause. They strengthen extradition. It's mandatory, but it's still a cooperative thing. At one point, the Congress used to understand this. You may recall from your constitutional law class the lottery case, the gambling case. It was actually aimed at Louisiana, although you wouldn't know it from the case. But in that case, the Congress actually understood cooperative federalism, meaning they didn't outlaw gambling in Louisiana. What they outlawed was passing or sending lottery tickets across state lines. Why is this necessary? Because in the federal arrangement, the states lose control over the borders. And when they do that, they have to be, in certain cases, protected from, quote, predator states. I would suggest to you this is a major issue where the Supreme Court is undermining what I call horizontal federalism, where there is supposed to be cooperation but limitation. And this comes up in the whole class action area, where prior to the Class Action, quote, Fairness Act, one state would be bringing all plaintiffs potentially from all over the country into a particular state court in one place. That violates all kinds of notions of federalism, and the federal courts did nothing to stop it. But the kind of cooperative federalism that Michael is most concerned about, I am concerned about, is the kind of crammed down federalism we have today. In the shutdown of the government just a few weeks ago, we heard that the administration, I guess through the Department of Interior, ordered that Wisconsin close its state parks because they were receiving some federal monies. Total distortion, even at its worst, of the spending clause. And we know the spending clause has been designed to get around the limitations on the federal government dictating and directing what the states do. Well, I'm being told, do I have 2 minutes or 1 minute? Oh, I have 2. That's a lot. Oh, that gives me more examples.
We're down a minute. We should all get extra minutes.
It is, when you look at our system, it was designed in such a beautiful way, and we've managed to mess it up, where it's an architected system that forces a regime in which you can cooperate horizontally, which we often forget. We think of federalism as being largely vertical. Yes, it's vertical, but it's also horizontal. The federal government has a role to play. So for instance, in the Class Action Fairness litigation, Act, instead of taking a federalist approach, Republicans took a nationalist approach. There would have been a very easy federal solution that they didn't want to hear, and that was Congress procedurally simply could have ordered the states, or legislated that the states cannot include in a class any plaintiff who is not in that state. Why did Congress not do this? Well, there are various reasons, one of which is that all the lobbyists were here in Washington, and although they may be on the conservative side, they think like Washingtonians, and everything out there has to somehow be organized. That is the nature of law from Washington. It has to be uniform. But also, it is because the sponsors of it are large corporations. Large corporations are opposed to federalism. They are not conservatives. Get that straight. They want one-stop shopping, and they don't care whether it's Washington or Delaware, but they don't want 50 states. But that is the system we were given. And in Washington, we have 2 versions of cooperative federalism. We have the left-wing Democrats and we have the right-wing Republicans, but they are all on the collaborative side. Thank you very much.
Well, I want to thank the Federalist Society and David Strauss in particular for inviting me to serve on this panel and for the judge for the nice opening remarks. Well, today I want to focus on state marijuana reforms. And I want to do so in part because they're the reforms, they're the area of law that I know most about. I've spent the last 5 or 6 years writing about them, but also because I think this is really probably one of the most important federalism battlegrounds of our day, based sheerly on the number of people who are actually affected by these regulations. It's in the millions, even the tens of millions in any given day. Now, back to Michael Greva's theory, this notion of competitive versus cooperative federalism, I think the mark of any good theory of federalism is its ability to incorporate examples from lots of different domains and to make sense of all of them, or at least to make sense of as many of them as possible. So I want to use this case study with state marijuana reforms to test some of our intuitions and notions about what we mean by competitive federalism. In particular, what makes competitive federalism work? What doctrines are consistent with it? And what doctrines might stifle competition? As well as what we mean by competition itself. Is it competition amongst the states to deregulate, or is it also competition amongst the states to regulate in particular ways? Now, we all know that the federal government bans marijuana outright. It's chosen the strictest form of regulation that's imaginable. It prohibits the possession, the distribution, the cultivation of this particular drug. Well, the states are now trying, and they have been for a couple of decades, they're trying to contest that federal ban on a couple of different fronts. And I think that they're having a great deal of success as to one, but not the other. In other words, competitive federalism is working in one instance, and it's failing in the other. The first instance, and the first thing that the states are trying to do, and it's what we usually think about, they're just trying to legalize this particular drug. In other words, they're trying to abandon their own state prohibitions on marijuana, these activities that are still prescribed by the federal government. Now, despite the tension, the obvious tension between these state laws and federal law, and despite the common trope that anytime there's a conflict between state law and federal law, the state law has to give way, it turns out that the states are actually winning this contest, hands down. In other words, notwithstanding the federal ban on marijuana, marijuana is de facto legal for everybody in 2 states, Washington and Colorado, everybody but minors, for example, and it's legal for a lot of people in another 18 that have these medical marijuana regimes. People are actually taking advantage and paying attention to these state laws, notwithstanding the federal ban on marijuana. And I think the success here is due to an important federalism doctrine, the same one that was mentioned earlier. It's the anti-commandeering rule. This doctrine that says that the federal government may not force a state to adopt a particular law, neither may it force a state to enforce a particular law. This doctrine is why Congress couldn't simply force the states to maintain their prohibitions on marijuana, and it's also why the federal government couldn't crowd out these state legalization measures. It's important to recognize that federal law enforcement resources are extremely limited. In fact, historically, the federal government has handled only a tiny fraction of all marijuana cases. States have handled about 99% of them. So as long as the states can withhold their assistance, as long as they have no constitutional duty to help the federal government enforce the federal ban, that federal ban may remain on the books, but in practice, it looks really, really weak on the ground. And that leaves the states a lot of room to operate. So here we have one constitutional federalism doctrine, this anti-commandeering rule, that is fostering some competition. Here, not so much amongst the states, but at least between the states and the federal government. But there's another doctrine that I think is stifling competition across the states. Now, the states here want to do more than simply legalize marijuana. They don't want to say that anything goes. Instead, they want to regulate it. In other words, they don't want to just abandon prohibition, they want to replace it with something else. And that's easy to see in the medical marijuana states. They're drawing a line between the people who are using it for, ostensibly, for medical purposes and recreational purposes. But even in states like Washington and Colorado, they're still trying to keep this drug out of the hands of minors, for example. And they proposed a lot of ways of regulating this drug. For example, some states like Colorado want to license marijuana distributors. And they actually have cameras that are in place in these marijuana shops that monitor the drug from seed to sale, that monitor it 24/7. But on this front, when it comes to regulating the drug and competing for different models of regulation, the states have been a lot less successful. And the reason here is a different constitutional federalism doctrine has constructed its preemption. In theory, in this particular field, Congress could actually preempt all state regulations of marijuana. In other words, Congress can't force the states to regulate this drug. That would violate the anti-commandeering rule, but it can stop them from doing so. It can completely eliminate all forms of regulatory competition with respect to marijuana. Now, it hasn't. I think there are a variety of reasons it hasn't done so so far, but preemption concerns have clearly stifled the types of regulations that the states have adopted. For example, following the repeal of alcohol prohibition in the United States, one way that a lot of states eased themselves out of this formerly very restrictive regulatory model was to take ownership over all alcohol establishments, to basically become the monopolist when it comes to the sale of alcohol. But you can't do that with respect to marijuana. That sort of regime, which would be a baby step compared to what some states like California are doing, that sort of baby step regulation regime would clearly be preempted. So no state has adopted it. Now, interestingly, in his book, Grieva actually endorses the anti-commandeering rule, which I agree with, but he also embraces preemption because he views preemption as a way of blocking this sort of cartel impulse among the states, this anti-competitive impulse among the states. But to my mind, it's not clear why, or in this particular instance, whether there is this cartel impulse and why we want to favor states deregulating this particular instance, going the extreme of having no laws on the books with respect to marijuana rather than having them take some baby steps. In other words, if we're really in favor of competition, then why not allow the states to compete on many different angles? Why not allow some states to continue with a prohibition regime? Have some states go the full 9 yards like California and have very few regulations in place? Have other states like Colorado adopt licensing? Other states like Maine, which is proposed in the past, actually taking ownership over marijuana establishments? Why not have this sort of choice in terms of the regulatory regime? But that's something so far that preemption has blocked, and it's not one I think that we can necessarily embrace. In other words, if we support competitive federalism, we might want to support both more state regulation and not just less. Well, to wrap up here, the main point I want to get across here is that anytime you build a theory of federalism, it needs to fit these different case studies. And I think that when we tend to use terms like competitive versus cooperative federalism, immediately it comes to mind the standard economic articles, the economic theories, which are concerned with things like milk processing in the states. They're concerned with those waste processing cases that litter the Dormant Commerce Clause field. Rather than all the other cases, the cases concerning same-sex marriage, the cases concerning individual rights, the cases concerning social issues and criminal issues. And the mark of a good theory is one that can be refined, perhaps, to start to take into account these other issues that don't quite so neatly fit into the model, and for which we might have different intuitions about the value of different judicial doctrines. All right, my time is up, but thank you.
So I too want to thank you all for inviting me to be part of this wonderful conference. And it's a pleasure to be able to reflect on Michael Grieva's book. I had the great pleasure of meeting him first a few years ago at a conference at the University of Texas where he and I and some other federalism theorists had gathered to debate the future of federalism. And it was there that we realized that he and I were both at work on books that challenged much of the conventional wisdom about federalism, although we came to these views from different places. We don't always agree on where we'd like to end up, but it turned out that we shared some pretty important points of agreement on where we start out. So, for example, Michael and I both agree that it's a misnomer to talk about federalism in terms of states' rights. Federalism is about people, we argue, and more specifically, the protection of individuals within systems of government. We both agree that states have more power than the conventional discourse has given credit to them, and that there are perils to be had both in over-centralization and also over-decentralization. But most importantly, we both introduce our books, unbeknownst to the other, with an invitation to Americans to think, as John beckoned us at the beginning of our program, to think less about what kind of federalism we have and more about what kind of federalism we want. And in doing this, we are implicitly acknowledging that the Constitution leaves open multiple possible answers to that question, all consistent with textual federalism directives within the Constitution, but pointing us in different directions. And so I'll come back in a few minutes to points on which Michael and I disagree, but I want to start by dwelling on this critically important point about American federalism generally, which is how much it leaves open to interpretation, not the least of which being the question of who should be able to interpret it. And so we see ourselves embroiled in this epic tale of American history, trying to make sense of the Constitution's promise of dual sovereignty. We know it's present in multiple provisions of the Constitution, but the Constitution doesn't answer every kind of question we could have about how it should work. We know there are two sources of sovereign authority, one that's housed at the federal level, one that's housed at the state level, but how should or shouldn't they interact? Should it be more according to the dual federalism model that John spoke of earlier, that idealizes more mutually exclusive, more separate spheres of state and federal power without a lot of interaction in between, which is consistent, I think, with Michael's theory of competitive federalism? Or should we see it as more of a marble cake model, emphasizing points of interaction and judicial overlap, which is more consistent with the cooperative federalism model that Michael worries about? Now, the first model, the dual federalism model, is more amenable to judicial enforcement because the identification of a bright line boundary between separate sources of authority is the kind of project that courts are really good at. But where we see it as more of the marble cakey, overlapping approach, then perhaps those are where we would have, we might call on the expertise of the political branches to allocate contested authority based on the kinds of expertise that elected legislators would have. And so what I'm discussing, obviously, is this ongoing and unresolved federalism safeguards debate that we've had, we've been cycling through over the centuries between periods of time where we're emphasizing overlap and judicial enforcement and competition, and periods of time where we're emphasizing, I said overlap when I meant separation. We move between periods of time where we're emphasizing separation, judicial enforcement, and competition, and alternating periods of time where we have emphasized overlap and political safeguards. And what I try to draw attention to in my work is that this dialectic between these two different approaches, these two different models of federalism, really stems from some unresolved tensions within federalism itself at the level of the values that underlie federalism, the good governance principles that we turn to federalism to help us actualize in government. And you'll all recognize the big four on the hit parade, starting with checks and balances that between local and national authority that protect individuals from government overreaching or abdication on either side of the line. There is the way that federalism fosters transparent and accountable governance, we hope, that enables meaningful democratic participation on all points of the jurisdictional spectrum. There is the protection of localism values, such as autonomy and diversity, that give rise to the interjurisdictional competition of the great laboratory of ideas that is at the heart of Michael Greaves' theory. And most overlooked, there is the problem-solving synergy that federalism enables us to harness between the unique capacity of local and national governance, the kind of government that happens best or can only happen at one level or the other, but which are both important to get at different parts of interlocking problems that really require some action from both sides for meaningful resolution, like, from my perspective, environmental protection, or also national security. And so the problem is that, and this is really the thesis of my own book, Federalism and the Tug of War Within, these values are each independently, intrinsically wonderful. We love all of them on their own. The problem is they operate in some tension with one another within our system. They're suspended in a web of conflict, such that you can't always satisfy each of these values at the same time, certainly not all the time. After all, The check and balance value is in inherent tension with the accountability value. If all we really cared about was having transparent, accountable governance that makes it easy for voters to understand which bums to throw out when we don't like how things are going, it's not bright to have two separate sources of authority. That's confusing. If we really wanted it to be transparent, we could have just one source of authority. We could have a centralized system like France. But we don't like that solution because we want to protect localism values. We could have a much more localized system of government, that more of a confederacy, a confederal system, rather than a federal system. But we don't like that. We tried it and it didn't work because it failed to grapple with some of the interjurisdictional problems we want government to solve for us, like the maintenance of open markets and interstate commerce. And so, because of this tension, we see this era, this tug of war, this pendulum swinging back and forth between different approaches, where federalist interpreters of the day will focus on one value to the exclusion of all of the others, usually without noticing it. So during the New Deal era, perhaps federalism interpreters focused on the problem-solving value to solve problems associated with the Depression at the exclusion of other values. In the New Federalism era that came later, hearkening back to other dual federalism eras before, we see more emphasis on the check and balance value, but to the exclusion of others. And I really think that the job of federalism theory going forward is to better understand these tensions and manage them in a way that gives consistent expression to each of these values as much as possible, because after all, that's what federalism is really for. Michael's answer to the challenge is to rely heavily on localism and check and balance values to enable more interjurisdictional competition between the states, though he does so without really acknowledging the cost to accountability values and with only passing sympathy to the cost for problem-solving values, which is consistent with his libertarian view that there aren't very many problems that worthy of being solved by either the state or the federal government. My own analysis parts company with his in two important places for our discussion. First, I do see a wider range of problems that cannot be solved by market forces alone, especially border-crossing negative externality problems like air and water pollution. And so I'm more solicitous of the problem-solving value than he is. The problem-solving value, after all, comes to us from the conservative principle of subsidiarity, that problems should be solved at the most local level possible, which couples a preference for localism with an acknowledgement that problems susceptible to regulatory solution should be solved somewhere. We should have the chance to try to solve them. But more importantly for our discussion, where I part company with Michael is that really, like John, I reject the dichotomy he gives us between the good, competitive federalism and the bad, cooperative federalism, which Judge Bea has already defined for us. I could debate Michael all day on the fairness of his characterization of cooperative federalism as collusion, but the point I really want to make here is that he's right. These are both choices we can make in how we structure our federalism. And as John has pointed out already, we've already chosen both, and they're both important. And what they have in common is that both the cooperative model, where state and federal actors take responsibility for separate parts of an interlocking regulatory whole, and the competitive model, where independently acting states goad one another and the federal government either to react toward or away from an innovation they've behaved, are both forms of interaction between local, state, and national leaders, thank you, in navigating the interjurisdictional regulatory problems that legitimately implicate both local and national authority or obligation. This is important, and I feel this strongly, because American federalism draws its greatest strength from opportunities for this kind of interaction between local, state, and national perspectives, not isolation. And so in my book, I catalog at least 10 different ways that local and national actors do negotiate, either collaboratively or competitively, the direction of interjurisdictional policies in ways that go far beyond the spending power bargaining that Michael worries about so much. And these kinds of joint decision-making, processes of joint decision-making, whether purposeful in a collaborative means or accidental or indirect in a competitive means, are so common that they belie a mythology that we see pervading the federalism discourse that I like to call zero-sum federalism. The idea that state-federal relations can be characterized as this antagonistic bitter winner-takes-all competition for power, when the reality of governance, when we look closely enough, as Rob has done, as I have done, really shows that the line between state and federal power is an ongoing project of negotiation at levels large and small that do give, in many instances, consistent expression to these fundamental federalism values. And I think this is an important point to make about how federalism in practice differs from federalism in rhetoric, or rhetorical conversations like the one we're having now about federalism. So to conclude, Michael sees threats in some of this bargaining, and those threats should be addressed. He's right. But I think when we look at the full tapestry of interaction between local, state, and national leaders, what we're really seeing is the best means available to ensure that local perspectives are appropriately consulted and incorporated into the evolving direction of interjurisdictional policies.
Ladies and gentlemen, Justice Beyer, thank you very much for having me. Thank you very much.
Judge Beyer,
Judge.
There's no justice in the Ninth Circuit.
There you go.
Not yet, Judge.
That's the German in me. There you go.
Forecasting the future.
Please excuse this. I would like to thank the Federalist Society for inviting me to this event, and I look forward to the discussion. I will try to contribute a brief comparative slant to this panel. And would like to start off with a caveat. Comparative thinking, I think, can add a new perspective, question very traditional ways of looking at things, shed new light on what we've been thinking for many years, just because a different society takes a completely different view on these matters. But there is also a limitation, and this limitation is important. It derives from the traditions, values, and the historical experience of different societies. Societies are very particular, and we need to take that into account when comparing. Now, federalism, I think, is a particular, potent area for comparison. And I will draw your attention to Germany. I'll invite you to travel to Germany just for a couple of minutes with me, because I think that Germany and the United States, although both key federal systems, could not be more different. And there are so many surprises in the German system. For American students, and vice versa. So many surprises in the US system for German students that I think these two are valuable in terms of their comparison. Now, given this background, my colleague Professor Baker said just a couple of minutes ago, I hope you won't trash the US system from the German perspective. I won't. On the contrary. I think it's surprising and interesting that both systems, though coming from different perspectives entirely, are facing very similar difficulties here in distributing and balancing regulatory powers and responsibilities between or amongst various tiers of government. The minority report of the Committee on Environment and Public Works, published 2 weeks ago, emphasizes some perceived deficits of cooperative federalism here in the United States with respect to the CAA, the Clear Air Act. It highlights the positive experience with this act over the past decades, but has a number of quite severe criticisms in the way cooperative federalism has developed. I mentioned 4. Closed doors, secret arrangements between environmental organizations and the EPA, unilateral action by the EPA regarding state air quality programs, difficulties in accessing crucial information held by the EPA, and finally, premature reconsideration of national air quality standards by the EPA. The report suggests a lack of cooperation between the federal administration and the states. Now, looking at Germany, you can say that there is, quite to the contrary, an inbuilt cooperation between the various tiers of government, which today is seen by many as excessive. So it's quite the contrary to this analysis by the minority in that committee. There have been, over the past decades, a series of constitutional amendments, which is, again, quite unusual if you compare the United States and Germany, that there actually are amendments to the Constitution on a very high level that try to rebalance the legislative powers between the Federation and the states. And currently there's a lawsuit pending in the Federal Constitutional Court in Germany targeting the financial equalization, an attempt, again, built into the system in Germany, which tries to provide fairly equal financial means to all states. They end up having roughly the same amount of money available for their policies. So both systems seem to struggle, both systems are maybe in trouble, but I think that these difficulties and these clashes play out within the framework of the wider constitution, and I'd like to highlight a couple of features of the German constitution which might be surprising given that it is a federal system too. First of all, there's the German Senate. If you go into the chamber, you will immediately notice that the states seem to be quite present. The coat of arms of the 16 states are there. The states have representations, embassy-like representations in Berlin, which emphasizes their strength, their authority, and their sense of uniqueness. In the Senate, the voting powers of the states are exercised by the state governments themselves. So the governors or their representatives would actually vote on federal legislation in the states, which means that the states are directly at the table when it comes to federal legislation. The balance between the two chambers is intricate. In some cases, the House, as we would call it here, is the most important body, the more powerful body, and can push through its views against the views of the Senate. But every time, and that is the second feature I'll come back to in a moment, every time the execution of federal law by state authorities, by state administrations is concerned, the Senate rises and becomes a very powerful voice, is needed to enact federal legislation. This brings me to a second interesting point, the concept of dual federalism, which is completely different. In Germany, rather than allocating legislative and executive power to one side and the other, most legislative power is exercised on the federal level, together with the states, as I just explained, but most laws you will encounter in Germany are federal laws. On the other hand, most administrations, most administrative bodies, and I would just venture to say 95% of them are state-run, state-organized, state-manned administrative bodies. So the states actually execute nearly all federal law. If you look for federal authorities, it'll be very difficult. Border control, military, the foreign service, a couple of others, but the bulk of public administration is exercised by the states. Direct federal influence on this execution of federal law is very limited, very constricted. Usually the Senate needs to agree. So the states are protected in this in the execution of federal law. And co-regulation with the federal government is actually done by the Senate. I'll come back to that point in a minute. So if you look at these features, it turns out that Germany has a kind of executive federalism where the Senate turns into kind of a clearinghouse for a number of issues. There are two other features which I would like to emphasize. One is financial equalization. As I said earlier, nearly all states have, or the states nearly have, just about the same money to spend. This is being criticized quite severely and is justified by the notion that Germans, wherever they live in the federal territory, should have fairly similar living conditions. That requires money, that requires financial equalization. On the upside, and this is perhaps important for our discussion, these funds are usually unconditional. The Federation has very little influence on how this money is spent. So a large part of it comes from the federal level, but the states are free in the way they actually use these funds. What is the effect of these various mechanisms that interact? I would like to take a look at clean air and just emphasize one or two difficulties in this very specific area. Germany, not surprisingly, as a very industrialized nation, has a very similar general instrumentarium and framework to that of the Clean Air Act. Now, this is a federal law, and of course it requires the setting of standards, as it does in the United States. But one important difference here, and that is directly tied to the constitutional separation of powers between the federal level and the states. The federation needs the states to actually regulate, to actually set standards. The federal government will do that with the help of statutory instruments, and these statutory instruments, because they are executed on the ground level by the administrative authorities of the states, will require the consent of the Senate. So each time the federation tries to implement a new standard, that will have to be done together with the states that are at the table. So that's one fundamental difference, I think. On the other hand, the application of the law by the states is again rather similar to the United States, in that there is a flexible application of these standards by the executives of the state authorities. So on the ground, the systems then again function quite similarly. When it comes to litigation, that perhaps is interesting as well. The citizen will actually sue the states, the state executives and the lender, the states themselves, if there are conflicts surrounding Clear Act regulations. So the states are defendants, and they are defendants in a case that involves federal legislation. Coming to a brief conclusion, I think that both systems, both the United States and Germany, both federal systems, operate in very different constitutional frameworks. The German is locked into cooperation or coordination, and the discussion in the country today is how can we achieve more competition? I'm not very hopeful on that count. As I said, the financial regulations are being attacked, the financial equalization is being attacked, past constitutional amendments have shifted more legislative authority to the states, but only on the fringes, not at the core. So it will be very difficult to change and introduce competition between the states that has been identified as desirable by many in Germany within that constitutional framework. Add to that financial equalization, as I said. On the other side, and I return to the minority report of the Committee on Environment and Public Works, looking just at one or two of the recommendations in that report. First, congressional oversight is invoked. We should have more congressional oversight, the minority says. There should be hearings targeted to the issue of cooperative federalism under the Clean Air Act. And two, related to that, Senator Sessions is quoted by saying, we should take time to listen to the ideas from the states on law to make common sense, bipartisan improvements to the CAA. This is something that happens in Germany, inbuilt, interlocked by the state's involvement in setting regulatory standards. So the Germans will have difficulty, I think, in the future, introducing more competition, while on the other hand, the states are less worried about the system of cooperative government simply because they are directly at the table in the Senate and can actually influence regulatory measures by the federal level in a very powerful way. So I agree, I think both systems have elements of competition and coordination. It's just the mix that is different. And I'm not sure, and I don't think we can really come to any conclusion here today, which system is more effective. Thank you very much.
Thank you very much. I'm going to use my position as moderator to start the questions going. And I'll start with Professor Baker. It won't come as any surprise to you that a federal judge's ears perked up when you mentioned CAFA. That's the Class Action Fairness Act. We have seen a tremendous amount of very inventive litigation in CAFA. Plaintiffs, just generally, if a class action, what's called a mass action, has a value in damages or recovery of over $5 million and over 100 plaintiffs, then there's federal jurisdiction to have it removed to the federal court. The result is that plaintiffs' attorneys seem to feel that the state courts in certain states are more favorable to them. And so they have some ingenious ways in which to put cases with fewer than 100 plaintiffs in different state law venues, and then consolidating them in a state law venue for coordination purposes, and then resisting any suggestion that if they have 75 here and 75 here and 75 here and 75 here, that adds up to 100. It doesn't add up to 100. It's 75 here and 75 here and 75 here and 75. Now, also we see attempts in Mississippi to bring actions in the name of the Attorney General, one plaintiff instead of 100. What do you see as a future in this tug between the plaintiff's bar that wants state class actions and the corporate bar, which quite clearly wants the cases to end up in federal court?
Well, that's a great question. I'm glad you asked it, because I wanted to talk more about that. I thought the act was bad to begin with, and I argued against it to no avail. Even talked to, at the time, Judge Kavanaugh, when he wasn't a judge, and I said, well, why is this thing going through? Here's a much more sensible way to do it. He said, yeah, but the train's already left the station. I mean, people had spent years invested in lots of legal fees on doing it a certain way. But the numbers that I looked at just recently suggested that it hasn't, I mean, I didn't know about this particular gamesmanship, but it hadn't played out the way they expected. The original argument was we got to stop plaintiffs from forum shopping, and what they expected were cases from very easy state jurisdictions to be removed to federal court on the assumption that the federal court is going to be better venue than the very easy state venue. But the numbers I saw said that, in fact, what plaintiffs are doing is bringing most of the cases in federal court, knowing they're going to end up there, but then they get to forum shop themselves. You know, having taught federal courts, I'm very suspicious when people justify something on the grounds of forum shopping. Forum shopping is a good thing if properly regulated. Indeed, it is in the nature of having two judicial systems. I mean, if we got the way to get rid of forum shopping is to get rid of the state courts. I mean, that would get rid of forum shopping, right? But the reason we have two systems is there is a certain competition. And competition among courts is very good. I mean, that's what we had in England under the King's Courts. There were 3 different courts, and they competed with one another. You know, my view is that you can't trust either the state courts or, excuse me, Judge, the federal courts. But it's nice to have them competing, and that's a good example of competitive federalism, it seems to me. I think what it has done is it has created a greater burden on the federal courts than was necessary. These cases need not have gone to the federal courts, and what it does is create much more litigation and therefore more case law for all of us to look at.
John's remarks put me in mind of an old Spanish gypsy curse, which is, may you have many lawsuits in your life and win them all. Let me ask Professor Michaels, the push and pull between federal and state authorities on the marijuana question, how realistic is it to these days when the federal government has quite clearly said that they're not going to prosecute simple possession? And I don't know if they're going to prosecute possession with intention to sell or sales. How do you see that is this an area of federalism tug of war which has disappeared?
Well, it's a great question. I think you're referring to the Department of Justice's memo back from August, where the DOJ signaled that it never promises to do anything, but just suggests that it's going to follow these guidelines. It actually signaled that it wouldn't handle simple possession cases. It's never done that. There are no simple possession cases at the federal level unless you bring marijuana to a federal courthouse or something along those lines. But for the first time, it signaled very significantly that there were some targets of opportunity that it realistically could go after, that it had the resources to go after, but it would decline to do so. Those are the big, really big sellers of pot. The federal government's never had the resources to really dent the marijuana market on its own, but it could make some people's lives miserable if it wanted to, and for the first time it's saying we won't go after these people. What's interesting to me is that the DOJ's announcement, in many respects, this is an example of positive cooperative federalism. There's got to be a reason why the Attorney General is saying we won't enforce a valid and existing federal law in these particular instances. And I think it's an instance where, at the behest of the states and at the request of the states who have repeatedly tried to interact with the Department of Justice, the Department of Justice is tailoring federal law. It's taking into consideration the interests of the states, but it doesn't sound nefarious to me in the same way that Grieva portrays cooperative federalism as necessarily being this, it's all about cartels, it's about the states serving their own interests. That may happen in some instances, but it's another good example of cooperative federalism. And I think it's just sort of the icing on the cake. Before this, the war was over. It was over years ago. It was over before Gonzalez versus Raich was decided. But this is just sort of the first acknowledgement of it, and I think it's a limited example of a good example of cooperative federalism.
I might comment that in Northern California, we were a little bit ahead of the curve. 2 or 3 years ago, there was a prosecution for not a small amount of marijuana, but indeed a warehouse full of marijuana, which was being distributed, and there was a guilty verdict, and the sentence was 1 day in prison, credit for time served. So we got there first, right?
Oh, yeah.
Professor Ryan, I have a couple of notes here that I'd like you to ask. First, on the theoretical basis, you talked about cooperative federalism and competitive federalism. At the very beginning, you said that you and Grieva agreed that what was really important was not states' rights, but people's rights. Which of these models, cooperative federalism and competitive federalism, gives the people greater liberty, greater freedom?
Well, if you ask Michael, he has a very clear answer. So Michael believes it's competitive federalism, and that hinges on his view that cooperative federalism is an act of collusion between state and federal bureaucrats that regulate for their own benefit at the expense of voter autonomy. So he has a very clear view on that, but I don't share it, partly because of the kind of answer you just heard from Rob. I don't accept the characterization of cooperative federalism as one of collusion. I have a sunnier view, I suppose, on voters' abilities to make themselves heard at the ballot box. I think we see lots of examples where voters are able to distinguish what they want from perhaps what their representatives have wanted in the past. And for that reason, I think that they are both in different ways. I feel like a broken record, but I think they are both in different ways actualizing they are both operating to protect individuals. One in the cooperative federalism case, through the attention to problems that I think individuals can't really solve on their own. And I think that there are quite a few, that's why we have government, to solve the kinds of problems that collective action problems and others that really require some kind of a gatekeeper or a referee or some kind of governance. And voters can't do that alone in a competitive environment. But then there are other kinds of problems where the kind of market competition that Michael bases his theory on is a very good way of allowing individuals to advance their interests. So I have to reject the either-or choice. It depends on the circumstances.
On a practical level, and in a particular area in which you teach, which is environmental protection, from time to time we see cases where the activists on environmental issues clothe themselves in federal law, and the local government responds more to development interests, economic interests. Do you see any trends in allocation of power between the federal and local governments in that type of situation?
Actually, I think environmental law is a great example of the value of a very dynamic, interactive federal system, because I think while there is truth to what you're saying about there having been times in history where local governments have been more attentive to the interests of development, perhaps, and those who are worried about environmental values or environmental goods are more interested in federal enforcement. But those periods have rotated back and forth, and this last decade is a good example where, in the absence of federal attention to certain kinds of environmental harms that activists were worried about, like climate regulation-related harms, the states have filled a regulatory void, as they would see it, that the federal government has not filled. And so the big difference, I think, is not between developmental interests or commercial interests and environmental interests. It's more between wanting regulation and wanting less regulation. So I think cooperative federalism is good for those who want more regulation, because it allows regulation to take place at either the federal level or the state level, and it allows either side to act as something of a regulatory backstop to the other. So to take the civil rights example, when the state governments were not advancing civil rights as in ways that activists wanted, the void was filled by federal interaction. Now, I'm talking about the civil rights era in the 1960s, now with, for example, the same-sex marriage movement, perhaps that has reversed for a time, and states began acting first and allowing same-sex marriage at a time where DOMA was still in effect. Environmental law sees the same thing. The federal government stepped in and regulated air and water pollution at a time that the states were not, but then when the federal government was not interested in climate regulation, the states stepped in. And so I think there's really, whether you like cooperative federalism or not, may have to do with whether you like regulation or not.
Okay. Professor Fedkin, let me ask you a question. I see if I understood it correctly. On the equalization of financial, I guess, distribution among the states, do the states raise their own taxes, or do all the taxes come from, do all the revenues come into the federal government from the federal government?
The federal and state shares are actually defined by the Constitution and further federal legislation. So the states would not actually tax you. The federation will tax you, but then distribute the shares between the states and the federal level.
So it's a rather original situation where the federal government raises the money,
That's right.
gives it to the states, and then takes its hands off and lets the state administer it.
That's right.
Well, we have some of that.
I mean, for the citizen, it makes things a little easier because there's just one tax return.
Now, if there's a clash between the federal government and the state government as to how to use the money or some measure, who settles that?
Well, the states will, as I said, actually execute federal law. So they are bound by that. And gross violations of federal law will end up in the courts, and the courts will settle the dispute between the citizen and the states. The federal level itself will have, if there's continued violation of federal law, some ability to intervene, but it is very limited. The courts will actually determine that.
Now, I'd like to spend the next maybe 7 or 8 minutes opening up to the panel. They may have some questions of any of them, and if they don't, we'll go directly to the public. Anybody have any questions of?
Professor Ryan mentioned federal government and same-sex marriage. We have not yet seen the outcome of the other part at DOMA in terms of federal government legislating in a way to, quote, protect one state from another state. What do you think of that?
Right, so the point is that while part of DOMA fell, the part that disallows the federal government from recognizing same-sex marriages, the part of DOMA that remains is the part that protects states from having to recognize same-sex marriages from states that allow it, states that don't want to allow it. And so your question is, what do I think of it?
Yeah, I mean, is that a legitimate exercise? I view it as a legitimate exercise of federal power where it's similar, in my mind, to the example I gave from the lottery case, where because you lose control of your borders. So if states are going to continue to govern their internal social affairs, that's a pretty big issue. And they can't do it by themselves without the assistance of Congress here. So is that legitimate use of the power of Congress under the Constitution?
So it's a great question, because if what we're looking for is the ability for states to navigate their own policies without interference by other states as well as the federal government, then yes, this part of DOMA is a very important way that uses federal authority to protect state autonomy in the way that Michael Grieve wants. So it's consistent with his competitive view. I don't see it that way in this particular issue, because I see the regulation of marriage, of same-sex marriage, as bringing in other constitutional values in addition to federalism. So I do see that I personally believe there's an equal protection issue at hand, and equal protection issues trump federalism issues within the way that we construe the Constitution. So that's my personal view.
I think that's going to be the argument in the Supreme Court, those two sides.
Anybody else?
Well, a question to my federal panelists in general. How do you see across various areas the ability of the states themselves to influence federal legislation? Of course, there's the Senate, and there's a Senate in Germany, but of course the composition of these two bodies are very different. You have federal legislators in the United States, representing the states, yes, and in Germany you have the state governments themselves, representing themselves in the Senate and participating in federal legislation. What do you, or how do you see that perhaps lack of direct state government representation in the United States, or is there no problem?
Well, prior to the 17th Amendment, I mean, the Federalist says it and Marshall says it, the states are represented in the Senate. That was the compromise. But they did it in such a way, not exactly the same way as Germany. It's, if you will, the yin and the yang. They wanted them representing the states, but they didn't want them beholding completely to the states. That's why they made sure that the pay came from the federal government, not from the state governments. If they wanted them tied to the states, but not too tied to the states.
I don't know how important those formal representations are as opposed to all the informal means of influence that the states have. You know, you've got powerful state lobbies. You've got the National Governors Association. You've got different lobbies that can pressure Congress, in part on behalf of the states, but I don't want to fall into that trap that I think sort of infects Grieve's book. It's not all just about the interests of the states qua states, but the states can actually lobby on behalf of their own citizens as well.
But
I think
look
that
at,
may be a
listen to what you said. You said the National Governors Association. That's the whole point in the shift. We have gone from, the founders understood that you respond to those who put you in office. The idea that you would have had unfunded mandates before the 17th Amendment is ridiculous. The state legislatures would never allow that, otherwise they'd yank them the next time around. They've had it, look, the idea, we have national lobbies on everything now. That's what it's come to. The states and the National League of Cities is more powerful. There are more cities than there are states. And the idea that a senator is in any way responsive to a state legislature, that is naive. You've never been in a state legislature then seen the action. There isn't any relationship.
But I don't think you need that, because ultimately I think both the state legislator and the senator are beholden to their voters. And ultimately, you know, there's going to be some interference with that. But if you've got some policy that is particularly popular at the state level, be it a particular abortion regulation, be it an immigration policy, be it a drug policy, I think you can have a powerful lobby that will stave off federal intervention in that particular instance, regardless of, the 17th Amendment came after lots of states have adopted direct election of senators. They were controlling senators through the people. So I don't think, I wouldn't overemphasize that formal representation, even though it is a stark difference between the United States and the German system.
I would also, I'm sorry.
The last comment, and then we'll go to the floor. Go ahead.
I was just going to call attention to all the other ways that I mentioned in my talk, a taxonomy of 10 different ways that state and federal actors bargain in governance. And to answer Professor Fetzi's question even more specifically, in Germany it seems very easy to identify from a distance the role that state actors are playing because they have this direct role in legislation. But when we look closely at the ways that federalism-sensitive governance operates in the United States, we have all sorts of different ways beyond just sort of crass interest group bargaining at the level of making legislation that state actors participate in federalism-sensitive governance here, ranging from not just sort of spending power types of deals, but interstate compacts that encroach with congressional permission on federal areas of authority, and pieces of legislation that invite different kinds of state representatives to craft parts of the law through state waiver programs, as in the Medicaid system, or other kinds of indirect collaboration on the direction of policy. A really good example is, I won't give it a good example because you wanted me to wrap it up for the interest of audience questions, but I would say that, look at my book. 10 different, there's a flyer outside, 10 different ways that state and federal actors bargain, which involves them much more deeply in interjurisdictional governance that is immediately obvious to the naked eye from a distance.
All right, we'll go now to the floor. Please state your name and indicate to who you would like to answer your question.
Mario Loyola, Texas Public Policy Foundation and New York University Law School. I wanted to direct this question to Professor Ryan, and I wanted to commend you, Professor Ryan. I really have to give you compliments on, I've never heard anyone give such a warm and pleasing and comforting glow to the federal takeover of state governments. It's really,
I'm glad it made you feel warm and fuzzy.
But I wanted to ask you, one thing that I've looked at a lot is what Michael Grieva describes as the disastrous intermingling of federal and state finances. Unlike in Germany, the states can tax almost everything that the federal government can tax. They are independent taxing authorities. And yet, state governments depend for 30 or 35% of their budgets every year, year after year, on the federal government. And what I would like to ask you, and it's sort of a trick question, but what I would like to ask you is why do the states need federal assistance? And isn't it really the case that it's the federal government that needs to purchase control of state governments through conditional federal funding in order to skirt the anti-commandeering principle of Prince by venturing into the territory of unconstitutional conditions? Professor Epstein walked out a few minutes ago, unfortunately. Otherwise, he'd be a center. Yes, exactly. But by skirting into the territory of unconstitutional conditions that, for the moment, is allowed to the federal government, but which, if the Supreme Court continues in the trajectory from Garcia to Prince and beyond, will hopefully soon be foreclosed. And if Professor Baker would like to add something to your answer, that would be lovely.
Well, you're happy to know that the court is already doing that with the spending power doctrine that comes to us.
Use the microphone, would you please?
I'm sorry, I wanted to add to your warm and fuzzy feeling. You'll be happy to know the Supreme Court is already on the trajectory that you want to see it in the new spending power doctrine that it set forth in the Sebelius case, the National Federation of Independent Businesses versus Sebelius. Yes, you're saying it's very small. Yeah. You're right. But it is the first time in the history of the Union that the Supreme Court has ever invalidated an act of Congress on grounds of exceeding spending power. So I wanted to continue the warm and fuzzy feeling and give you that. But I do agree with certainly the second part of your assertion. You said, isn't it true that what's really happening is that the federal government needs the states to implement federal priorities? And as Rob was talking about with regard to marijuana enforcement, that is certainly true. It's true in environmental law. It's true in all of these areas of cooperative federalism where it's clear that when the states if the states walked away, the federal government couldn't possibly do what it wants done on its own. The part that I thought was perhaps missing from your analysis is that when the states participate in these agreements, it is also because they want something that they can't get to on their own. Bargains only happen when both parties need something from the other side. So you're absolutely right that the federal government needs the boots on the ground enforcement capability, the expertise, the local expertise, all sorts of things that only the states can give. And the federal government usually has something that the states want enough to participate in these bargains. And sometimes it's money, oftentimes it's money. And the spending power doctrine puts some limits on that money that weren't there before, or the use of money, the force of money. But there are also other things that the state wants. Michael Grieva thinks the states sometimes want things that are illegitimate in his view. They want to be able to to regulate to their own advantages. I obviously disagree. But I think there are also times where the states want the ability to tackle a problem with boundary crossing spillover effects that they can't do on their own. And so there are other good reasons besides just being bullied why states participate in these programs.
Will Judge Bell allow me a follow-up, please, since she pointed out that what was missing in my analysis?
I'm sorry,
Can I put-
we have people waiting over here. Would you please state your name and your question?
Yes, sir. Howard Wellens, Washington and Lee School of Law. My question is primarily for Professor Fetke, but if others would like to chime in, I'd be happy to hear their opinions. You articulated that one of the reasons why the independent states in the German Federation seem to be so cheerfully cooperating with the federal system is that they have such a pronounced seat at the table, with there only being 16 states. Hypothetically, if the German country had 50 states and serviced a much larger population over a larger landmass, how do you think that would affect that ability to cooperate? It might be a difficult question, but I'd like to hear your response.
I'll try to take it. First comment. Some Germans believe 16 are too many, even. And that, of course, is interesting. I mean, I emphasized at the beginning of my remarks that the states have their coat of arms in the Senate, and they have their embassies, kind of, in Berlin. So there seems to be a strong ethos. We are separate, we are individual. But there's been a discussion that some states are not viable. They should be merged. So 16 might be too many. Now, could Germany cope with 50? And my colleague, Professor Baker, just said, well, that's the EU. Well, 28 there at least. And the model is the German model of federalism. It's exactly the same, to the point that parts of the German constitution have been used as a blueprint to create the European Union and how that works. Now, of course, the EU is faced with one additional slant. It's not one country. And there are issues of sovereignty which are less pronounced within Germany. But I still think, even with a larger number of states, that giving state governments, with their experience in actually executing law, bringing it to the people on the ground, have a lot to contribute to federal lawmaking. Now, constitutions change over time. That's another thing to bear in mind. They evolve, whether through court decisions or real-life developments. And the German system has evolved. Is there really still the sense that the German Senate represents the states with very distinct interests from the federation? Perhaps just on some occasions, but they come up again and again and again, where regional differences will be voiced in the Senate across party politics lines. So that's one feature which I really like about the German system, that party politics play less of a role in the Senate. 1 out of 100 sessions will be really controversial and along party politic lines. Otherwise, it will be about solving the problem. And in a way, the Senate is a body in Germany which improves federal legislation, federal bills, because those senators are governors and they know how this can work or not work in their states on the ground. But again, the EU perhaps is halfway to the 50 states, or more than halfway, and seems to be working, at least in those areas that were copied from Germany.
Thank you very much. Next question.
Yes, my name is Art Mackenber, and I'm for Professor Mikos and perhaps Professor Baker. I'm interested in this marijuana issue because in North Idaho, our state police are seizing gargantuan amounts of marijuana going over to Washington. And so in terms of preemption, my understanding is that there's a root of that power in the federal government vis-a-vis the states, where if the Constitution limits that power to the federal government, then the federal government can only legislate on it, bankruptcy, immigration perhaps, some of these things. And then when we look at, the U.S. Supreme Court looks at preemption cases, they usually look for some express language from the federal legislature that says, you know, we are preempting all state law, that type of thing. But with marijuana, this seems to me to be clearly an exercise of state power where they're protecting the health and safety of the citizens from the use of illegal drugs, and I think that My understanding is that's the origin of those laws, is the state police power. But then I hear the federal government has no generalized police power. So is this memo that came out of the Justice Department perhaps just an implicit recognition that the federal government has no power to regulate drugs? And if they do have the power to regulate the use of drugs, and it's not a police power, what is your understanding of the source of that power constitutionally?
No, there's nothing in the DOJ memo that would suggest a lack of constitutional authority on the part of the federal government to step in and prescribe marijuana. And in fact, you can argue against it. You can argue against the Gonzalez versus Raich case, but the source of this authority is typically specified as the Commerce Clause. Now, what's interesting is that the Department of Justice, when it said we won't prosecute certain individuals even though they're violating federal law, one exception it made to that was precisely the scenario that you raised at the outset, that if there is activity in one of these marijuana legalization states that is spilling over into another state, that would be a situation where the DOJ would step in. If they knew that there was some big supplier who was taking the drugs out of Colorado or Washington, shipping them into Idaho or Montana, that they would step in and crack down. So interestingly, in a sense, the DOJ is narrowing the role of the federal government in this particular instance, but it is focusing to some extent on sort of those classic areas where we might all agree there's a role for the federal government here. It's also saying, though, at the same time that it's concerned about the use of marijuana by minors, so that if people start to sell it to 16, 17, 18-year-olds in Colorado, it's going to step in. And that, I think, is a constitutionally more problematic assertion. That looks much more like the state police power. But at the very least, the DOJ is saying, we're worried about this. We're worried about the externalities from one state to the next.
We're going to have to take two more questions. One last one over here and then one over here.
Thank you. I'm Jean-Baptiste
Try to
Legnero.
keep them short.
Yes, short. Jean-Baptiste Legnero from the French Council of State. I'm working for the European Union Council, which is somehow the Senate of the Union. And my question was for Professor Ryan, based on what Professor Fetke just said. Do you think the controversy, the debate between cooperative federalism and competitive federalism could be appropriate for the European Union to try to solve its problem it's faced now? And do you think there are studies on this question in the US? Thank you.
So if I understand, the question is the debate that we're having about competitive versus cooperative models of federalism in the context of American federalism. The question is that an appropriate debate for the European Union to be taking on and thinking of how to move forward? Oh, it is a wonderful question that I feel completely unqualified to really weigh in on, because I'm not an expert in European Union federalism. The only thing I can say is my understanding of European Union federalism has always been that it is already a more competitive environment than the American. My understanding, which I say with great qualifications, again, not an expert in European Union federalism, is that American federalism has much stronger central power than European Union federalism does, and so it already looks more, I think, like Michael Greaves' model of what he'd like to see in American federalism. And yet, I also think that the hurdles of the European Union in organizing around unifying principles to move forward has been perhaps challenged because of the lack of central authority. So I'm not sure if that's a good thing or a bad thing, but it seems to me like it's already more competitive.
I don't think it's as sunny as she describes. That is why in the treaty in 90, when was it subsidiarity was added? 92? 92. Okay, the reason subsidiarity was put in as a principle was this very issue of over-centralization.
All right, quick question, Ilya.
Yeah.
We're
so
right at the
I'll
point.
be brief. You guys have touched on a lot of really interesting and important points in competitive and cooperative federalism. One that you didn't touch on much, except by implication, is that a potential benefit of competitive federalism is the ability of people to vote with their feet. Instead of simply being able to go to the ballot box to try to influence the policy we have on, they can vote with their feet. And that has many implications, actually, for things that all four of you have said, but I'm not going to try to list them. I'll just throw that out to you if you have any comments on how that might play into the theories that you outlined. Thanks.
Voting with your feet is extremely important, and it goes with competitive federalism because that's what forces the competition. I mean, look at Illinois. They raised their taxes and Rick Perry goes from Texas up there and invites all the corporations to come down, and guess what? Some biggies have moved. You know, and California can get away to a certain extent with raising its taxes, but I know some wealthy people who've left California because of the taxes. That's being able to vote with your feet, but if you were in Germany, what's the point? Because the taxes aren't going to be any different, and it's going to be all distributed the same anyway. But, you know, as Professor Fedke said, it's the difference culturally. We don't have the commonality. I mean, Europe looks more at solidarity, something we didn't even talk about here. Americans look at individualism much more. The Europeans think, well, why are we so individualistic? Well, we don't get along on a lot of things, that's why.
But I would have to say, Ilya, thank you for this important question. I would have to say it's such a bedrock part of Michael's theory that it's also subject to criticism even from within conservative circles. You probably know Ernie Young's criticism that
I wrote a review of the book myself where I criticized him.
Right. So what I'll just say quickly is that I think it over-relies on the concept of exit at the exclusion of the loyalty part of that three-part triangle, because it's not, it works better for businesses than individuals. The data shows, the social science shows that most individuals will never leave their home state, let alone their home county, no matter what mix of policies are in place, for reasons that go beyond politics and have to do with family and community. So while it's a better account for commercial behavior.
That is not true. I mean, you know, in the crash in the 80s, the sign in Houston, Texas, the bumper sticker said, "The last person out of Michigan, turn off the lights." I mean, people do
I think the statistics are 75% of people never leave their home state.
Not true.
What is your statistic, Ilya?
So according to a Pew survey from 2008.
On that cooperative note, we want to thank the panel.